Hello, and welcome to the Muckler LP update webinar on the changes to TUPE legislation in the January 2014 window. My name is Chris Maddock. I head up the employment team of 10 lawyers at Muckler LP in Newcastle. I'm joined today by Francis Barker, who's a senior solicitor in our team and specialises in TUPE transactions in particular. So I'll click you onto the next slide and you can have a good look at us and see us sitting here today. So what will we look at this afternoon? We're looking at the changes which have been brought through as a result of changes proposed by the coalition government, and we were going to start by looking at the basic purposes of TUPE and giving an update and refresher for those of you that perhaps haven't done as much TUPE as others. A brief overview of the current situation and the current issues that we face, and also the position in relation to the changes, looking in particular at what will come into effect on the 31st of January and a couple of subsequent changes that the new regulations impose, and then trying to give some thought to how this will impact on your organisation and the work that we tend to do in advising employers on both sides of the TUPE transaction. So it's worth thinking about the purpose of TUPE. What is TUPE? Well, TUPE is the shorthand for the Transfer of Undertakings Protection of Employment Regulations. The latest full version of those regulations is a 2006 statutory instrument, and that came into force in April 2006. TUPE as a concept has been with us since the early 80s, so it's now more than 50 years old, and as with much of our employment legislation, is an implementation of European legislation. The whole idea behind TUPE was to deal with a situation where somebody buys a business. There are two really main ways of structuring a business acquisition in the UK. You can either do what's known as a share deal or an assets deal. A share deal is very simple because it means that if you buy all of the shares in an undertaking, you get the legal ownership of that undertaking and all of the relationships that come with it. So the employees continue being employed by Joe Bloggs Limited, and there is no change to their situation. What TUPE was intended to cover was the situation where the assets of that business were in fact sold. So the purchaser picked up the contracts, the premises, and all of those other aspects. And the concern was, in those circumstances, that the employees could be left behind in Joe Bloggs Limited and not transfer automatically across. So the whole purpose of the Acquired Rights Directive was to try and protect employees in those situations, and to say that if that situation arose, then those employees follow the business. What TUPE went on to do was to try and protect the terms and conditions, so couldn't allow an incoming employer to erode those terms, and it provided that employees going through that situation would be consulted about the transfer, and in particular whether any changes or what are known as measures under TUPE speak were going to be taken again in relation to them by either the outgoing employer before the business was sold or after the business was acquired. So what's the problem? The problem with TUPE is that it's extended beyond that buying and selling of businesses to substantial changes of contractors in particular. So whether there's been a contracting in or a contracting out of a service, quite often a catering, cleaning, other ancillary service, or that service is taken back in-house. It was what happened to those individuals who might be working in that undertaking. And what happened through a huge amount of case law during the 1990s and early 2000 in particular was some positioning around whether employees transferred as part of those transactions. What happened in 2006 was the idea of a service provision change transfer was introduced, which was to cover the scenario that I just talked about, contracting in, contracting out, or bringing a contract back in-house. And it was to ensure that in those situations TUPE did apply, rather than it being subject to case law and factual considerations which were separate and different in each case as to whether 2P applied or not, and were, I suppose, quite clearly being abused by certain employers faced with that situation. So, what has been the issue that's arisen as a result of transfer situations is that because the automatic transfer principle, where transfers have happened, and I suppose the 2006 regulations have made that more certain for employers, even though there has been some concern that there are certain contracting out or contracting in situations where that necessarily doesn't follow that the staff should transfer, and that's what some of the changes we'll talk to you about shortly are intended to address. The other main issues which the government sought as part of this consultation to try and clarify what happens around the automatic transfer principle. So under TP 2006, what is very clear is that employees transfer on their existing terms and conditions of employment. Whether it changes post-transfer, they have to be very carefully dealt with. So any dismissal by reason of a transfer is automatically unfair unless there is an ETO reason, so unless there is an economic, technical or organisational reason entailing changes in the workforce for that dismissal. The problem comes where you are changing contracts of employment, and that is quite often done by means of termination and re-engagement on new terms. Whether there existed entailing changes in the workforce was always a substantial consideration, because to entail a change in the workforce there must be a change in terms of numbers or in terms of the composition of the workforce. So imposing change by changing the contract on notice, which was the ultimate fallback position, is not something which has been able to be relied on with any certainty. So if we look at what employees have in that situation, they've got protection against dismissal. So dismissal in connection with a 2P transfer, as I said, is automatically unfair unless there is that ETO reason. What 2P also provides are the obligations to inform and consult if there are any measures, and knowing who to consult and when, even if there aren't any measures, has always been an uncertain issue. Under the legislation as drafted, even if there are no measures proposed by either the outgoing or the incoming employer, arguably employee representatives should be put in place to be consulted with regarding the proposed changes and to be provided the information which 2P specifies must be provided. What also happened, and was a new concept in 2006, was the obligation on the outgoing employer to provide the incoming employer with employee liability information 14 days before the transfer. It's a good idea, but in practice it's been a really difficult issue to deal with for outgoing contractors and incoming contractors in particular, because quite often when the tender process is done, where somebody has to price an incoming job, they don't know what the employee liability information is like to be, and have to make a number of assumptions unless there is some contractual provision under the previous contract to require the outgoing contractor to comply and to assist in the consultation process. So that was a new concept. It works well on planned transactions, but not on changing contractor situations. So there have been a number of pitfalls or a number of areas where the judges have had to step back in to try and sort out issues as 2P has developed further beyond the provisions in 2006. One of those has been around determining when there is a service provision change, and we'll look at some of those changes and what's required under the new provisions, which largely mirror where the case law had got to shortly. Electing representatives, as I said, there's quite often, especially with small groups of perhaps 5 or 6 cleaners affected at an institution, an argument as to whether you need to elect representatives to represent them or can speak to all of them individually. The new provisions were hoped would clarify that slightly. The next area which has been a pitfall is the area I just talked about, where there is the issue of whether there is a valid ETO reason to allow changes or to dismiss employees after the transfer has happened. And the final area where there's been some concern and a large element of dispute between employment lawyers over the years is about the crossover between the TUPE regulations and those affecting collective redundancy consultation. So it is commonly an issue if you're buying an organisation and they're doing it by an assets transfer, and you will then relocate that organisation geographically to somewhere distant. So you're buying something in Manchester and you're going to relocate it to the northeast of England, then the issue would become, could you, in the run-up to that TUPE transfer, also carry out the necessary 30 or 45-day consultation process required to allow those redundancies to take effect on transfer, or did you have to wait for them to transfer to you to be your employee before you could start that 30 or 45-day consultation? The new changes do make actually quite a lot of difference in terms of certainty in that area in particular. So hopefully that gives you some background as to the current position. What Francis is going to look at now is the rationale for change and just give some background on how we've got to the regulations which will come into effect on 31st of January.
In the context of the pitfalls that Chris has just explained, I'm going to summarise the rationale and the changes that are going to be implemented shortly. Firstly, in November 2011, the government issued a call for evidence on the effectiveness of TUPE. As Chris has already mentioned, there were concerns that it was too bureaucratic, overly protective of employee rights, etc. And then there was lots of confusion about when there was a service provision change, or whether it should be removed altogether. In addition, the government sought views on the crossover between TUPE and the collective redundancy consultation, as Chris has mentioned. The government's response was published in September 2012. Initially, this response concluded that there was scope to amend TUPE and to remove the gold plating around employee protection. In addition, Vince Cable said there needed to be further consideration around whether to remove service provision change altogether. However, in January 2013, the government issued a consultation paper with the proposed changes to TUPE. And in summary, the proposed changes were the repeal of the service provision change element of TUPE transfer, along with a number of other issues. But as I'm going to come on to talk about in a second, largely a lot of the original changes that had been proposed, and Chris talked about earlier, were dropped at this stage. So on the 31st of October 2013, finally the government published the draft Collective Redundancies and Transfer of Undertakings Protection of Employment Amendment Regulations 2014, and these are the regulations that will be shortly coming into effect this month. The draft regulations were laid before Parliament in December 2013, and as mentioned, they're about to come into force. No changes were made at the final stages between December and January.
And I think the major thing that came out of the regulations in the form that they have been introduced now is that the issue of service provision change has actually been removed. So they are not going to drop the service provision change application under the 2006 TUPE rules. Those provisions around contracting out and contracting in will remain. And I suppose as an employment lawyer who grew up during the 90s, and the case law which came down from the European Court of Justice at that stage, the uncertainty around TUPE transfers and the problems that caused was actually a major disrupting influence for business. And I think sense has prevailed. There were substantial submissions made by the Employment Lawyers Association and other groups as part of the consultation, which said actually, let's clarify when a service provision change may exist, but let's not throw the baby out with the bathwater, because otherwise we'd have gone back to looking at each TUPE scenario, and there'd have been people trying to avoid or to argue that there was a transfer, depending on whether it suited their purposes or not. So the service provision changes will remain in the legislation going forward, and that's probably the biggest thing to understand from what's coming in at the end of the month.
And the only point that is going to be implemented on the service provision change is the legislation now clarifies that the service must be fundamentally the same before and after the transfer. That was never in the TUPE regulations originally. However, that's a position we've got to in case law anyway, and so I think it's mine and Chris's feeling that this isn't going to change anything in practice. The second point just to mention on this slide is in relation to the employee liability information. This is the sharing of information before the transfer that Chris mentioned earlier. Essentially, there's an obligation on the transfer or the outgoing employer to provide information to the new employer about the employees and their terms and conditions and whether there are any claims, etc. It used to be that had to be provided 14 days before the transfer. They had consulted on dropping this provision altogether for the reasons Chris had explained, but actually they've decided to retain it, but instead just to extend the deadline. So for TUPE transfers that occur on or after the 1st of May this year, 2014, the employee liability information must be provided no later than 28 days before the TUPE transfer. In fact, my experience is if the TUPE transfer is still some way ahead in the future, actually parties start sharing the information about the employees well before that date anyway. This next slide is in relation to terms that are derived from collective agreements. This is largely relevant to transfers from public sector employers such as the NHS. Where the terms and conditions that are in the employment contracts are not necessarily all agreed with the individual, but could be derived from a collective agreement agreed via a trade union. The regulations that are being implemented in January are now confirming that a static approach will apply to those terms at the point of transfer. This means that if the ex-employer, so the public authority, continues to negotiate collectively post-transfer and those changes would have impacted on those employees that transferred over. In fact, the employees that were subject to transfer remain on the terms and conditions that were effective at the date of transfer. So the changes that are made post-transfer, even though they're collectively agreed with the unions, they do not apply to the employees that have transferred over out of the public sector employer. And the rationale behind that, of course, is because their new employer isn't necessarily going to be involved in those collective negotiations. Actually, that's a position we recently reached in case law anyway, but it was only in the last year, so I think it's right that it's being confirmed in the regulations itself now. The second point on this slide is just to confirm that the regulations that are being implemented in January are now going to enable the transferees, so the new employer, to change collective terms 1 year after the transfer, provided the changes are no less favourable to the employees. I must admit, from my perspective, I'm a little frustrated that this doesn't go further, because my experience advising clients is that it's not just collectively agreed terms that are very difficult to change post-transfer, it's individual terms as well. And initially the proposal had been that it would be made easier to change terms, any types of terms and conditions post-transfer, for instance, to allow harmonisation. But unfortunately the regulations do not go that far. It's specifically in relation to collectively agreed terms, and it only allows changes 1 year after the transfer date. Chris has already mentioned the economic, technical or organisational reason, which is the reason that has to be used to justify dismissals and also changes to terms and conditions on a TUPE transfer. The current position is that there will only be an ETO reason if it entails changes in the workforce. and that's defined as changes in the numbers or functions of employees. But unfortunately, it doesn't go as far as to cover a change in the location of the employees. This has made it very difficult where there's been a redundancy situation on a TUPE transfer that solely arises because of a change of site. For instance, the buyer or the new service provider is unable to maintain a site where the employees used to be retained, but they're not actually reducing the numbers or the functions of the employees. It's just simply they're going to have to move everyone to another location. At the moment, that doesn't fall within the ETO reason, and so potentially that redundancy situation could be automatically unfair. Going forward, it's been made clear that the ETO reason is going to be extended to cover change in location, so it should make redundancy situations much easier to manage in that scenario. Just going on to the next slide, this is the point that Chris mentioned earlier about the crossover between collective redundancy consultation and TUPE consultation. It's always been something that's been very difficult to advise on from an employment lawyer's perspective, because technically the legislation didn't seem to allow the collective redundancy consultation to start pre-transfer. The regulations that are coming to effect this month are going to enable this to some extent. However, it's been made clear in the regulations that there has to be an agreement between the transferor and the transferee that the redundancy consultation will commence pre-transfer. And so it doesn't go as far as to just, opening it up completely to enable consultation pre-transfer. There has to be some agreement on the process and how it's going to be carried out. And the other important point to note is that the ETO reason that enables the dismissals to be fair in a redundancy situation will still sit with the new employer, so the transferee or the buyer or the new service provider. So although the consultation can start pre-transfer, the dismissals themselves cannot actually happen until post-transfer. Clicking on to the next slide, this change is unlikely to impact on a huge number of businesses. Unfortunately, we thought it would go further than this. This relates to the requirement under TUPE to appoint appropriate representatives where there is not already a recognised trade union to consult with. For both the purposes of informing the employees that are transferring of the TUPE transfer and also consulting with them, the TUPE regulations require you to appoint appropriate representatives and go through an election process if there's not already a recognised trade union. And we hoped that that might be removed where, for example, the TUPE transfer only involved a small number of employees. What in fact the new regulations do state that micro businesses, which are ones with less than 10 people, will be allowed to inform and consult directly with the employees that are transferring. But you could still have a larger employer that only has, say, 2 employees transferring on the TUPE transfer, and unfortunately they will still have to appoint appropriate representatives. Now, I have to say, in practice, it doesn't necessarily mean that people follow that strictly to the rule, and actually sometimes a commercial approach is taken and they decide that they're going to consult directly with the individual employees anyway, regardless of what the legislation states.
And if you ask their approval for that and they agree, then it's very hard for employees in that situation to subsequently complain, is our experience. So, yeah, having a common sense approach for small numbers of transferring people is often the way to go.
Just one point to note on that, actually, it's in relation to TUPE transfers that will take effect on or after the 31st of July 2014. So although we'll see it in the legislation from the 31st of January, this only applies to the later TUPE transfers. Finally, the government has been promising for some time to provide guidance on TUPE, because up until now we've never had any official sort of guidance that we can look at, a bit like the ACAS Code of Practice. This has now been published by BIS, and you can find it online. But I have to say, having read through it, a lot of it is based around the legislation, and where there's any uncertainty around certain issues, such as the crossover between collective redundancy and TUPE consultation. Unfortunately, the BIS guidance just says that these issues will be determined by the courts. It doesn't give a whole, it doesn't put a lot of meat on the bones. So skipping on to the final slide, we're just going to cover how will this impact on businesses. We've really covered the points on this slide already. It's just to say that the service provision change amendment in the regulations is not actually going to impact on businesses significantly, because the wording that's now being included was already covered in case law anyway. The extension to the employee liability information deadline is unlikely to impact on practice unless there is a tight turnaround for the TUPE transfer, in which case it's just worth being aware that 28 days before the transfer is the standard provision for providing employee liability information, although I have to say there are provisions in the TUPE that allow for last-minute disclosures if it is a very tight timescale anyway.
And I think from our perspective, the type of clients that we have, that service provision change is the area where there's the most uncertainty and the most scope for dispute between the outgoing employer and the incoming employer. You only have to think about the situation where somebody had lost a contract that they didn't want to lose. They're not going to help you out. They're not going to provide you with information unless they're absolutely required to do so. And they're going to want to maintain a harmonious working relationship right up until the transfer if they can. And quite often, as an incoming employer in those situations, you really have to push the opposition and to push for the information and to push for the consultation against quite an unwilling occupying employer. So we're going to have a look now at how this will impact on the business, in particular around harmonising terms. I think, Francis, this is probably the biggest area where we get involved.
Yeah, and as I was mentioning earlier, one of the problems that we often have is discussing how to change terms and conditions of employees post-transfer. And I must admit, when I read the changes that were going to be implemented in January, I was a little disappointed that it restricted the changes that will be allowed going forward to just collective terms and only after 1 year following the transfer, which seems quite a long time. My view is there's going to be an awful lot of case law around this, trying to determine whether the changes have been made properly, particularly because the legislation doesn't allow less favourable changes to be made, and there's going to be a lot of case law around what exactly that means. It's also, as I mentioned, less relevant to the private sector as well, because it's all about collectively agreed terms and conditions, and unfortunately doesn't go as far as allowing changes to individual terms.
I think we'll see what has developed, which is where there is change and there is harmonisation. Even if that is agreed, it is dealt with by a formal termination and re-employment on new terms. So notice is issued, and quite often settlement agreements, so the old compromise agreements as was, are entered into with the whole group of employees to make sure that they're not likely to come back later and try and argue about the effectiveness of that change or any potential claims they've got in relation to the way in which it was done.
I think I can skip through the next couple of slides reasonably quickly, given that we've already talked about the ETO reason being extended to cover changes of location earlier on. As I mentioned, this is going to increase the freedom to make fair dismissals on a TUPE transfer, particularly relating to redundancies by reason of a site closure. Also looking at the crossover between the TUPE regulations and the redundancy consultation. In practice, a lot of our clients have tended to take a commercial common sense view, as Chris mentioned, and started redundancy consultation pre-transfer anyway. But this did have risks, given that it had never been tested in the courts. We'd never actually got any case law allowing this to happen. So at least the regulations now actively recognise that this is a possibility. And finally, just coming on to the micro businesses again, I mentioned earlier that unfortunately this doesn't go as far as to allow all employers to consult directly with employees rather than appointing appropriate representatives. It's only going to impact on employers with less than 10 employees, and not where the employer is larger but the employees transferring is less than 10. There's obviously a slight difference there. It's unlikely to help significantly and still does not solve the practical problem where there's only the duty to inform as well. So where no measures are being taken on a TUPE transfer, as I mentioned earlier, technically under the TUPE legislation you still have to appoint representatives for the employees, even though the reality is all that you're doing is sending them a letter informing them of the TUPE transfer happening and the likely date of transfer.
Thanks, Frances. So we're in a position, I suppose, where there is some change to an employer's benefit of the changes under the regulations. It could have gone further. Unfortunately, it hasn't. And there'll be a few things that need to settle down, particularly around post-termination, post-transfer harmonisation in particular. So we hope that you found that session of use. We are still very much in our infancy with these type of sessions and would value any feedback that you've got. Or if you have any specific queries or wanted to contact either Frances or I or link to us on LinkedIn, we are happy to give as much information as we can, and we'll try and keep you updated on anything as and when it arises in this area and others during what looks to be a very busy 18 months or so to come. Thank you very much.
Thank you.
Bye.